The Fair Housing Amendments Act, FHAA, was signed into law on September 13, 1988, and became effective on March 12, 1989. The Act amends Title VIII of the Civil Rights Act of 1968, which prohibits discrimination on the basis of race, color, religion, sex, or national origin in housing sales, rentals, or financing. The FHAA extends this protection to persons with a disability and families with children. This law is intended to increase housing opportunities for people with disabilities. However, individual citizens must come forward with concerns, file complaints, or sue if they believe their rights have been violated. The government has no other way of detecting discrimination as it occurs. As a result, it is important to understand this legislation and how to make it work for you. Understanding the Fair Housing Amendments Act will help both persons with disabilities and advocates better understand the FHAA. Who is protected? The FHAA added persons with a handicapping condition, along with families with children, as protected classes under the Civil Rights Act. The legislation adopts the definition of handicapping conditions found in Section 504 of the Rehabilitation of 1973, as amended. This definition includes any person who actually has a physical or mental impairment, has a record of having such an impairment, or is regarded as having such an impairment that substantially limits one or more major life activity, such as hearing, seeing, speaking, breathing, performing manual tasks, walking, caring for oneself, learning or working. Types of housing facilities covered. This law pertains to all types of housing, whether privately or publicly funded. Some examples of types of facilities include, but are not limited to, condominiums, cooperatives, mobile homes, trailer parks, timeshares, and any unit that is designed or used as a residence. It also includes any land or vacant property, which is sold or leased as residential property. Prohibited actions. The FHAA prohibits a wide array of activities that discriminate against persons with disabilities and families with children in the sale or rental of housing. The following specifically outlines illegal actions. Refusal to sell or rent a dwelling unit when a bona fide offer has been made, where the refusal is based on race, color, religion, sex, disability, familial status, or national origin. Imposing different terms and conditions or treating people differently with the provision of service because of race, color, religion, sex, disability, familial status, or national origin. Discouraging an individual from living in a community or neighborhood if the restriction is based on race, color, religion, sex, disability, familial status, or national origin. This activity is frequently referred to as steering. Advertising, posting notices, or making statements in such a way as to deny access to an individual if that denial is based on race, color, religion, sex, disability, familial status, or national origin. Understanding the Fair Housing Amendments Act. Understanding the Fair Housing Amendments Act. Misrepresenting the availability of a dwelling because of the applicant's race, color, religion, sex, disability, family status, or national origin. Blockbusting by encouraging the sale or rental of a dwelling by implying that people of a certain race, color, religion, sex, disability, familial status, or origin are entering the community in large numbers. The FHA expands the traditional list of prohibited activities to actions which relate directly to discrimination based on disability. The following are examples of such activities. It is illegal for a landlord to refuse to allow a tenant with a disability to make modifications at the tenant's expense, which would permit the tenant to fully enjoy the premises. The landlord can, where reasonable, require the tenant to restore the interior of the premises to the condition it was in prior to the modification. Premises are defined to include interior and exterior parts. Therefore, refusing to permit a tenant to make modifications to a lobby, entryway, parking lot, or laundry room is also discriminatory. Asking a question designed to determine whether an applicant or anyone associated with that applicant has a disability is unlawful under FHAA. However, the Act does provide for certain inquiries, provided they are asked of all applicants whether or not they have a disability. A housing provider may ask, if an applicant can meet the financial requirements of ownership or tenancy, if an applicant is eligible for housing that is available only to persons with a disability or a specific disability, if a person is eligible for a priority available only to persons with a disability or a specific disability, if a person is a current substance abuser, if an applicant has ever been convicted of the illegal manufacture or distribution of a controlled substance. Reasonable accommodations. FHAA requires two types of reasonable accommodations to make existing housing more accessible to persons with disabilities. These accommodations consist of structural modifications and policy changes. Structural modifications. Housing providers must permit reasonable modifications of existing premises if such modifications are necessary for a person with a disability to be able to live in and use the premises. The cost of the modification is to be paid by the resident with a disability. Reasonable accommodations. FHAA requires two types of reasonable accommodations to make existing housing more accessible to persons with disabilities. Modifications may be made to the interior of the individual's unit, as well as any public and common use areas of a building, including lobbies, hallways, and laundry rooms. Modifications may be requested in any type of dwelling. However, in a rental situation, the landlord may reasonably condition permission for a modification on the following: the renter agreeing to restore the interior of the premises to the condition that existed before the modification, ordinary wear and tears excepted. The renter providing a reasonable description of the proposed modifications. The renter providing reasonable assurance that the work will be done in a workmanlike manner with all applicable building permits being obtained. A renter should be aware that a landlord must not increase any customarily required security deposit. However, where it is necessary to ensure with reasonable certainty that funds will be available for any necessary restoration at the end of the tenancy, the landlord may require that the tenant pay a reasonable amount of money, not to exceed the cost of the restorations, into an interest-bearing escrow account over a reasonable period of time. The interest earned on the account accrues to the benefit of the tenant. This means that when the tenant with a disability moves and the unit is restored to its original condition, any money left in the account is given to the tenant. As a result of these rules, FHAA has, in effect, created three classifications of modifications: modifications that do not have to be restored, modifications that need to be restored to the original condition, but do not require the establishment of an escrow account, modifications that need to be restored and are relatively expensive. Therefore, an escrow account may be required. An example of the first modification category would be widening a bathroom door, which does not affect the usability of any other space, such as a closet. Here, a wider door would not affect the next tenant's use of the apartment. A modification, which may fall in the second category, would be the removal of a base cabinet under the kitchen sink. In this situation, the next tenant would want the storage space under the sink. Therefore, the tenant with a disability would be required to restore the cabinet. The cost to replace one cabinet would not be tremendous, so in escrow, the account would probably not be required. If all the cabinets in the kitchen were replaced and the counter lowered, which is obviously more expensive, an escrow account may be required. The traditional example of a situation where an escrow account may be needed is when a tenant removes the bathtub and replaces it with a roll-in shower. Remember, although a landlord may condition permission, he/she cannot deny permission for modifications needed so that the tenant with a disability can use and enjoy his/her home.